which usually means it's unconstitutional.
Could you even argue that this is, even under Sherbert, kind of a weak case? Because if it's a historic landmark, that has to do with civic things. I'm sure a lawyer could make the argument.
Somebody probably could. It would probably lose. Do we really think that preserving one historic landmark is a compelling government interest?
I do.
And that's the thing about the Sherbert test. It's not weighing the religion's interest against the general interest in preserving historic landmarks. It is weighing the religion's interest against the government's interest in preserving that particular historic landmark, which is a much harder argument to case.
Yeah, so it can't be specific. Yeah, Sherbert's kind of like a bad resolution because it's not even really doesn't even say anything.
Yep.
Okay.
Yep.
No, I kind of like it as a federal standard, though.
Why?
It's so vague; it doesn't solve hardly anything.
Why do you like it?
Well, it seems like it's more restrictive on the federal government's ability to impose like national standards on behavior, which I think is just a good thing for the federal government to decide. Like, not necessarily constitutionally we shouldn't have Sherbert. I like that. I like the Smith test for like the Constitution, and I like that that's what the states have to go by.
So just a general.
I kind of think that this turned out like the best way possible,
okay.
Which is that the states have to abide by the Constitution, but the federal government can have its own standard that doesn't apply. Like, they can't strong arm the states into going along with it as well.
We'll see if you still think that at the end.
I don't know. I think in theory that's like a very well constructed system, but
yeah. I mean,
we'll see what happens.
Yeah, I mean, aside from the rest of the story, I mean, because RFRA is just a law passed by Congress, it can be overridden by just another law passed by Congress.
Yeah, which is what Scalia had in mind, right? He said like the balancing act would take place in legislature,
right?
And that's basically what happened.
Right. Okay, so moving on to the next thing, the Religious Liberty Protection Act. So this is basically Congress looked at what went wrong with the Religious Freedom Restoration Act and it tried to fix it. So it wrote a law basically applying the same standard but relying on the spending power and the commerce power. So saying that the Sherbert-Yoder standard applies to any state program that is taking any federal money or to anything that affects interstate commerce, which is going to be most things. This law failed. The difference, I think, was as much a matter of timing as anything. So after Smith, lots and lots of people were unhappy with the Smith ruling. This includes, by the way, the Americans and Liberties Union and Americans United for Separation of Church and State, as well as all the right-wing people. All of those people wanted the Religious Freedom Restoration Act, which is kind of disturbing. But by 1998, we have the gay rights movement, and that causes it all to fall apart. So the issue that they were concerned about is where it goes up against discrimination. So they were particularly concerned with landlords that didn't want to rent to gay couples. In some states, there were laws that said they had to. But if you've got something like the Religious Liberty Protection Act, then the landlord can say, well, my religion says homosexuality is a sin. I can't rent to gay couples. And so that's where the conflict came in there. And so by 1998, we have the gay rights movement opposing this, and it all falls apart, and the law fails. So that's where federal law has ended up. The state, a number of states have passed their own versions of RFRA in their state legislatures, which is obviously valid. A state legislature can.
Is Virginia?
I have no idea. Some other states have courts that have interpreted their state constitutions to mean something closer to Sherbert-Yoder than Smith. So in about 31 states now, we still have essentially the Sherbert-Yoder standard applied to state law as well as federal. That's because of decisions that were made at the state level and therefore can be undone at the state level if people want to do that. So that's more or less where the law has ended up. The last piece of this is the Religious Land Use and Institutionalized Persons Act. So after the Religious Liberty Protection Act failed, Congress wrote this thing which only applies to land use decisions and people and institutions, which is usually prisons. And this, again, applies the Sherbert-Yoder standard, essentially, to those two sets of cases across the country. But it's just those two areas. And since neither of those really has implications for civil liberties or gay rights or anything like that that anyone can really think of, that wasn't really opposed so much, and that passed. So that's the end of where the law is now.
Wait, what does it mean, religious land use and institutionalized person? Like, can go into a prison and convert people, or what?
So the land use part is, zoning decisions, building of churches, things like that. So that gives religious institutions a leg up on that stuff. The institutionalized persons.
Wait, what's an example of that? As in, someone trying to buy a business, or lease something, and someone else wants to make it a church.
Well, I mean, as I understand it, land use, if you want to build something, you have to get approvals from the local government, and that's a very subjective process. There aren't very many standards for that, and so local governments that don't want new churches to come in and build, which they often do not, can come up with some reason about traffic flow or something like that to not let the church build. So this gives churches a way of coming back and building their building. Okay, so that's the land use part. And then the prison part, that can be something like the Jewish prisoner wants kosher meals.
And so they're saying, you have a right to that?
Yeah.
Okay. What about, domain,
Doma?
not doma, eminent domain, yeah.
Eminent domain.
Does that have anything, what if that gets all turned down here? Religious land
How would
use?
that happen?
Federal domain,
Eminent domain.
eminent domain says
So-
you need
so-
this land,
so-
and it has a church on it.
So you need this land, and so the government wants to take land that has a building, that has a church on it, and build something else on it.
Yeah.
I do not know the answer to that, so I'm just going to move on. That's okay.
Okay, yeah.
They'll probably just do it anyways, because they do it for private businesses.
No, I'm just wondering if this applies.
Right,
or...
but if Arlupa applies, that could potentially give the church a legal leg up that a business wouldn't have, and I'm not sure how that would come out.
I'm sure it'll happen sometime.
It probably has, and I just don't know about it.
Okay. Maybe.
That's a good question. Yeah. So moving on. So the general issue of...
I think
you skipped.
Oh, I did. Just skip. There we go. Okay. So yes, exemptions versus civil rights. So just yesterday, a court in Hawaii had a case where some bed and breakfast owner didn't want to let a lesbian couple stay there because this person didn't thought homosexuality was a sin and all that. So that violated a Hawaii civil rights law, and the Hawaii court said that the civil rights law stands. But that's the kind of case where civil rights runs up against these kinds of religious exemptions a lot. So you've got that with the bed and breakfast owner. You've got that with the wedding photographer who doesn't want to take pictures of a gay wedding. You've got that with the city clerk who doesn't want to sign a marriage certificate for a gay couple.
And just last week, something like that happened in Washington State. There was a florist who she'd been selling flowers to a gay couple for years, and they were finally going to get married because it had become legal in Washington to do so. So they wanted her to do the flowers for the wedding, which is very different from just selling flowers. She just has to plan it out, be very intimately involved in the ceremony. Right. She said she didn't want to do that because of my relationship with Jesus Christ. And they took the case to court and came back and said she would have to provide the service. If she provides it for heterosexual couples, she has to provide it for homosexual couples.
Right. Yeah. Now this is all coming up at the state level because federal law doesn't protect homosexuals from discrimination. pretty much in any circumstances. So it's all coming up in those states that have state laws that prohibit discrimination on sexual orientation. So it's all being decided in state courts on state law, and the outcomes are varying from state to state, but these are the kinds of things that are coming up there. So does anyone have any thoughts on this clash?
Yeah, so like why can't the federal government do something about that? Like why is it up to the states to make sort of like laws of like homosexuality?
If Congress wanted to pass a law prohibiting discrimination on sexual orientation, they could. They just haven't.
They're coming under pressure to decide one or the other.
What's Hosanna to War versus the EEOC?
That's another case that the legal grounds for that case are somewhat different, and I'm not going to go in there because that's a whole separate line of cases, but it's very much the same sort of conflict between civil rights laws and religious people wanting their own rules. So basically what happened in this case, we have this elementary school teacher, I believe she was a 4th grade teacher at a Lutheran school. She takes a leave of absence because some disease. She's protected by the Americans with Disabilities Act, or at least would be, if she were employed by an institution that wasn't religious, it's very clear she would be protected by the ADA. So, being a teacher in the Lutheran elementary school, there comes a point when she's ready to come back, and at that point the conflict erupts and she threatens to sue, which according to the Lutheran Church, apparently, and you can decide for yourself how seriously you think this is as a religious belief, but the Lutheran Church believes that disputes should be resolved within the church and not taken to the civil court system at all. So just making the threat was, a violation of the Lutheran faith, and so they fired her based on that, and that goes up to the Supreme Court last year.
That's harsh.
Yeah, yeah. And so the Supreme Court rules, and this was disturbingly quite unanimous, that for a ministerial employee, which the court says Ms. Perrick, the person in the case, was a ministerial employee despite being a general 4th grade teacher. For a ministerial employee, federal civil rights law just doesn't apply. They can discriminate on whatever they want. Federal civil rights law, and civil rights law generally is not going to restrict that. So even if your state has a law that says you can't discriminate on a particular characteristic, churches, religious institutions still can for their ministerial employees. So this means, for example, that if a church fires its minister because they don't like the color of his skin, that is legally okay. The minister will not be able to sue.
And this applies to all states? This is federal?
Yeah, this is as a matter of interpretation of the establishment and free exercise clauses. There's still a sort of open question about whether it will apply to contract law. So if in the employment contract between the minister and the church it says the minister cannot be fired because of such and such characteristics, is that legally valid? And that's the Supreme Court specifically said that that was beyond the scope of the ruling. It wasn't deciding that, so that's an open question.
Has that ever been put in any ministerial contract?
I have no earthly idea.
I'm
sure someone will now.
Be
If it hasn't happened, if it hasn't been in one before, I'm sure it will be now. So that's another case where civil rights law versus religious people wanting to do whatever they want. So does anyone have any thoughts on all of this? To what extent do you think civil rights law should be overridden by religious people's beliefs or not?
Pretty far.
Every case.
I mean,
We all believe.
at the same time, the Catholic Church bars women from the priesthood. So
It does. And this was one of the really big things that was on the table. They were worried about how not to tell the Catholic Church to ordain women.
I mean, I feel like it really would be restricting, it would be going against the free exercise clause to tell a religious institution that they have to include such and such kind of person in their ministries if that is against their religion. I mean, because then that's not a matter of it's specifically like entering into how they're running their religious practices and telling them you have to do this a certain way, even if it's against their religious beliefs. But then the other side of that would be, at what point does it become an issue where this religious institution is restricting somebody's civil rights? Does somebody have a civil right to taking a certain job within a religious institution?
They always say generally people have a civil right not to be discriminated against in employment on the basis of certain characteristics like race, sex, religion. Why? If it sounds like you're saying that religious institutions should be different from other institutions for those purposes, why would that be?
That is one aspect of my whole thought process that I had jumped ahead of.
Yeah. And I mean, I guess the sort of standard argument is that that's a much more personal relationship than most employment relationships. You know, the extent to which people trust their ministers and are intimate in their relationships with their ministers is much greater than most employment relationships in society. And so that's an interesting.
Not only that, but I think that in any case, in most cases, I guess, like the Hosanna case, it seems like if they wanted to fire her, or if they didn't want to hire someone based on some certain characteristic, and the Supreme Court turned that down and said, no, you cannot discriminate based on, I don't know, like gender or something, the church would find another reason or some other way to make sure that specific people didn't get hired in their establishment. So.
Right, and I mean, that's a general problem in employment law. You know, people who don't want to hire blacks, for example, can often say they're doing it for other reasons, and courts in general are able to look into the facts and decide for themselves whether or not they believe the reasons that the employer is giving.
Right, so if we have that same standard for every other place of employment, then, and people still manage to get around that, I don't see why we treat this any differently, seeing as people will still find a way to get around it. Like, in terms of like, I mean, not that that's really a reason.
Well, I mean, a lot of times people don't get around it. Courts will say, sometimes say to a certain employer, you're bullshitting us.
Yeah, no, that's true. I mean, they'll find some other way. I mean, yeah, sometimes you can't bullshit it, but definitely in some cases they will find some way to bullshit it. So, not that that is an arguable reason to put a law in place, but in the grand scheme of things, how much of a difference does it really make? It could make a big difference, but it won't make as sweeping of a difference as the church probably thinks it will.
Well, I mean, in the Hosanna Tabor case, I think the facts were pretty clear that, you know, if there hadn't been a special rule carved out for religion, you know, she would have had a perfectly valid ADA claim. She would have been awarded damages under the Americans with Disabilities Act. So I mean, there are definitely cases where employment law works. Where
I'm not saying that. I'm not saying it's like all futile or anything. I'm just saying like we're really skeptical about it. Yeah.
Yeah, I don't know what the numbers are on employment law cases. I don't know. I'm not even sure how you measure something like that.
Is there?
That's a good question.
I'm sorry.
No.
Go ahead.
Is there a way that the federal, like the Supreme Court, could somehow establish whether civil rights precede the non-establishment clause? Like
This is free exercise clause.
For the free exercise clause. Would there be some way, some standard that they could uphold that says this is where the line is drawn, where people can practice their religion freely up until the point of infringing on people's civil rights? Is there any sort of law that could be made to establish that?
Well, I'm with under Smith, the Constitution itself, I don't think it's going to run up against civil rights all that much. I mean, the Hosanna Tabor case it did. It's kind of weird. As I said, that's actually a separate sort of legal line of cases that was decided under. But yeah, under the free exercise exemptions issue in general, I don't think there's going to be that much clash, just because there's very few times that the free exercise clause says that there have to be exemptions. So that leaves it all to either Congress to decide, if it's going to protect civil rights of some kind, whether it's going to carve out an exception for religious people. As I said, there are, and sometimes it has. So in the employment context, the Hosanna Tabor says says that churches can discriminate on anything with respect to their ministerial employees. There is a separate clause in the statute that was written by Congress that says churches can discriminate on the basis of religious belief only with respect to any of their employees whatsoever, ministerial or not. So Catholic Church can insist that its janitors be Catholic, even though that has absolutely nothing to do with the job of sweeping floors. And that's perfectly valid. That was upheld 9-0 by the Supreme Court in Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints versus Amos. So yeah, that's a matter of Congress passing laws and then the Supreme Court interpreting them. At the state level, which, as I said, is where a lot of these come up. If you've got a state Religious Freedom Restoration Act versus a state Civil Rights Act of some kind, ultimately, or versus a state constitutional provision, that's going to be decided by the state courts. As a rule, the federal courts defer to the states on the interpretation of state law. So that's not even for the federal government at all.
Has there ever been a case where a place of employment requires, for example, their employees to be like black or white? I mean, in the basically since probably 1980.
Has there been? As a matter of practice, I'm sure, for example, African American churches will insist that their pastors, who are probably, in most cases, their only employees, be black. I'm sure there are other churches in the South that would go the other way.
Yeah. Or that way, even.
Yeah.
Casting for television, film, commercials, often they'll want a specific person to meet, like not just like a racial thing, but like you have to be this tall.
Well, but that's valid. I mean,
like it's, and they're allowed to because it's like your ability to perform the duties required rests upon like your physical appearance, because we need to sell like a certain image because of like artistic license and things like that.
Have you ever?
No, it's totally fine because they're just a license, but that doesn't have anything to do with
like Abraham Lincoln needs to be white in this movie. Sorry.
Yes.
Yeah. I mean, certainly you can. That's actually, there's actually a third exception to employment non-discrimination law called the bona fide occupational qualification exception, which basically says if it's really, really, really required for the particular job, then you can discriminate on this characteristic that's really, really, really required. And I think requiring the actor who plays Abraham Lincoln to be white or the actor who plays Thurgood Marshall to be black, I think would both fall within that exception.
But then it's not like a huge stretch to say that the Catholic Church can decide to only hire Catholics to certain positions. And then if you don't meet a standard,
you can't play Abraham Lincoln if you're not white and tall and thin. You can sweep the floor of the Catholic Church without being Catholic.
Yeah, maybe. Well, let's put aside the fact that I disagree with civil rights legislation's ability to tell people what they can and cannot do.
Really?
Yeah, I think they should only apply to governments. But let's put that aside for the moment. I think that we have the Establishment Clause. I mean, the Free Exercise Clause. We have, and it refers to religion specifically. So whether we like it or not, there is a distinction between the actions of a private citizen based on their whims and the actions of a private citizen based on their religion. There is a legal difference there, correct?
Arguably. I mean, to the extent that even under Smith and Likumi, there's certainly protection against discrimination on the basis of religious belief. That's very clear. It may go farther. It's not so clear.
Mm-hmm.
But I mean, that could certainly be analogized to something like the Equal Protection Clause protecting people from discrimination on the basis of race.
Yeah.
A clause that tells the government not to discriminate on a particular characteristic isn't necessarily privileging people who are, religious or black or whatever else.
But it seems like we might need to clarify what counts as a religious opinion, or what counts as a part of a religious ideology. Like the idea that you should keep matters inside the church and not go to the government is not something that I've ever heard of before, and I know plenty of Lutherans. So that sounds like a bullshit justification for basically non-controversy within the church, which is not a valid religious principle. So I think that it's kind of strange that they treated it like it is, and it's kind of strange that they upheld the termination of this woman.
Well, I think there are two sort of concerns there that they had. One was if the courts start asking that question about what's really a religious belief and what's not.
Yeah.
That's sort of intruding into the area where they have to start interpreting theology, and they really, really don't like to interpret theology. And two, I don't know how many Lutherans would be aware of that rule, but it's certainly been written down in Lutheran documents for a long time, taught in Lutheran seminaries for a long time. So it's not like they've just made it up through litigation.